Thank you so much for coming to this session. Is human rights scuppering democracy? So we're reading in the news every day that we have up to 1 million illegal immigrants arriving in the UK, 35,000 illegals arriving just this year on boats across the Channel. And people are asking, are the rights of illegal immigrants a higher priority than the democratic wishes of the UK public and the British Parliament? Because after all, we have the last 10 years as a country in many different ways expressed the wish for greater control on immigration in a number of ways. So what should we do about it? And on the other hand, surely human rights are a good thing, capital G, capital T. Surely they're there to help defend freedom and rights such as the freedom of speech and the right to privacy, amongst other things. So what can be done about this conflict? And to help us through these tricky waters, we have 4 wonderful speakers. If I can just introduce them quickly. On my far left is Dr. Natalie Alkiviadou. She's a senior research fellow at the Future of Free Speech, Vanderbilt University. Her PhD is in law. She's also author of 4 books which focus on the far right, hate speech, and European law. Welcome, Natalie. And then on my immediate right is Dr. Shirar Ali, former deputy leader of the Green Party, who worked in the Science and Tech Unit of the European Parliament, but really came to prominence in a case of belief discrimination against his own Green Party, in which he won £100,000 damages that were awarded to him for his fight for his gender-critical beliefs. Welcome, Shirar. And then on my left here, I have Professor Gavin Phillipson, Professor of Law at Bristol University, who researches comparative constitutional law and European UK comparative human rights law. His published work is widely cited around the world in legal judgments. And then on my far right is John Holbrook, a barrister, a writer for publications such as Critic, Spiked, and Conservative Women. Like Shirar, he also faced blowback for espousing his beliefs and views, and has used his legal experience to fight for free speech for himself and for others. So all the speakers are going to have 6 minutes each to try and put their understanding of the issues in front of us. Then it's going to come out to you guys. If you could keep your comments as concise as possible, and then we'll be able to bring back the panel for sort of questions and answers. So without more ado, Natalie, would you like to kick off?
Yeah. Okay. Thank you so much. Thank you for having me and the invitation. I've got 6 minutes basically to try and sum up what I'm thinking in terms of the ECHR. I'm going to refer mostly to speech cases, hate speech cases, which are, the kind of area of ECHR that I study. Several commentators discuss, the issue of deportation and the regular migrants, or the issue of immigration more generally when it comes to the ECHR and the decisions. But there are a lot of other rights under the European Convention on Human Rights which affect the UK and other member states of the Council of Europe. And one of them is the freedom of expression. And when I was reading the description of this panel, it referred to British values. And I think one of the basic values that you have in Britain is right to freedom of expression. You were, very strong in developing this right also within the framework of international human rights law in the drafting of the European Convention on Human Rights. So as a foreigner, I when you say British value, one of the values is freedom of expression. The European Court of Human Rights has been absolutely awful when it comes to some of these hate speech cases, we have systematically seen the court agree with states that limit things like, take case of Ferrer versus Belgium. It was a politician of the National Front who said in a leaflet, protect Belgium from Islam the Conqueror. And he was fined and he couldn't take office for 10 years. And the ECHR agreed that, this was correct. Belgium acted correctly. I'm going to give you just a couple of examples to make my point. The case of Liljedahl versus Iceland. A guy had written a comment under a post regarding some support system for trans students in schools. And he said, "Oh, this is disgusting. This is, what is this?" The kind of comments about trans students. And he got fined. He got, these are all criminal penalties, by the way. And the ECHR came and said, "No, that's not allowed. We mustn't offend people," and what Iceland did in fining him was okay. We've had the case of Norwood versus the UK, a big hate speech case whereby a guy put a BAP post out his bundle saying Islam must Britain, protect the British people. And now that case is very worrying because there was no legal analysis of Article 10, which was the right to free speech. There's different steps, like was it necessary, was it proportional? They just used Article 17, which prohibits the abuse of rights clause. Prohibits the abuse of rights to just kick his case out. So he had no kind of legal assessment of his claim. So hate speech case is very worrying at the ECHR, at least for me. I'd really like much more substance in the assessment. But at the same time, that doesn't mean that I think that, we mustn't have the ECHR or we mustn't have Strasbourg or we mustn't have some kind of human rights framework. And I'll give you an example. There was a young girl a few years ago, and I'm from Cyprus, I'm Cypriot, and she had come over to Alinafa, if you know, the town, a party town, and she was brutally gang raped by 10 men in a hotel room. And our legal system was absolutely horrific to her. It's a case of X versus Cyprus, and we were absolutely awful to this young girl. And we even charged her for public mischief. We never considered her claim and anything. It was absolutely awful. It was humiliating and, awful. And she sued us, Cyprus, at the European Court of Human Rights. And the European Court of Human Rights came back and said, "You know what? You have been sexist to this girl. You have been awful. You have humiliated her, etc., etc." So without the European Court of Human Rights, she wouldn't have some form of redress. Let's not forget that the European Court of Human Rights is a court that you appeal to after you've exhausted your remedies on a local level. So on the one hand, I'm also confused. I don't really have an answer. I'm very, very skeptical, to say the least, of speech cases at the European Court of Human Rights. I am very worried about that. Also, I find it awful that even very basic, that essentially the court is adopting a viewpoint restrictive stance toward the freedom of expression. It's even imposing obligations on states to legislate and investigate alleged hate speech cases. So even if it's a case whereby a state decided, there's no case here, I'm not going to investigate, the ECHR has come in several cases against Armenia, Bulgaria, several other countries and said, no, you should have investigated. You shouldn't have had a law that criminalizes this. So it gets even more worrying. But on the other hand, I give you the case of the guy in Cyprus and say, okay, what do we do with this? So I don't know how long I have left. Maybe a minute?
You've got just over a minute.
Just over a minute. So I think what I would say is, in terms of immigration, because I know my colleagues are going to discuss that more, we always have to remember that even if we the states within the Council of Europe region forgot the ECHR, let's not forget that we have international human rights law, the Refugee Convention, prohibits the principle of non-refoulement. So leaving the ECHR, leaving all these kind of institutions doesn't necessarily mean that things will change in terms of immigration. But at the same time, at the moment, we have the European Convention on Human Rights with certain limitations on freedom of expression. Those limitations could get much worse if we gave it to the government to choose, right? With even more limitations in terms of, discrimination or hate speech. There could actually be a provision on that. So I would be very, very worried leaving that to government. So just to sum up, hate speech cases, if you are interested to see what the ECHR is doing wrong in terms of freedom of expression, then have a look, because it's systematically doing it. It's always prohibiting offensive speech. It comes to the point where it says even prejudicial speech is not to be allowed and is to be dealt with under criminal law. And that for me is worrying, and I'm stopping now and hope.
Dr. Sharahi, maybe.
Thanks so much, Eve. So let me start by answering the question that's been posed. Are human rights scuppering democracy? Of course, I will elaborate, but my answer to that is no. They are not scuppering democracy. That's if they are well understood and interpreted. So what could well be scuppering democracy is bad interpretation, bad implementation of the law as it is, not as we'd like it to be. A follow-on question to that is if and when the law and the application of it is being subverted, how do we deal with that? Even the judiciary has been known to have been captured. What I'll do in this short introduction is saying a little bit about the case that has most involved me legally in terms of gender-critical discrimination. And if I have time, I'll touch a little bit on the merits of the European Convention of Human Rights with respect to freedom of expression, particularly with respect to religion and religious belief. So firstly, as some of you may know, I was subjected to, as the court found, unlawful direct discrimination by the Green Party. This was the first case of its kind, and the first time a political party had been found guilty of perpetrating belief discrimination at all, let alone gender critical. Now, why did I feel I needed to go to court, and what judicial instruments were we taking advantage of? Well, the main one, of course, is the Equality Act. And some of you may have just come from the previous session around work ideology. Just to pick up on a point was made by Kura Reindorf, which I agree with, which is why I will defend the Equality Act. Her proposal really is that we're not in this country so much interested in quality of outcome, although we can be if you're particularly from a party of the left. We are particularly interested in equality of opportunity. And one of the ways that the Equality Act very deftly negotiates that problem is to make sure that we effectively have a negative liberty, a liberty not to be treated a particular way. That's very different from a positive proposal, as you might get in the United States of America, like positive action quotas. That's not what's being proposed in the Equality Act. It is a very strong mechanism by which we can protect people against unlawful discrimination on various grounds. That doesn't override. It's not to say that you need to be seen in all days of the week simply in terms of certain identity characteristics. That's not what it's about. But it is an attempt to protect you against certain forms of very oppressive situation based on race, on sex, and other indicators. So my case differed, I would suggest, from Forster's case, although it very much relied on her. And what a champion of human rights, Miles. She went all the way to the appeal tribunal. And they said one of the levers that we were furnished with was the idea that her belief, gender-critical belief, was worthy of respect in a democratic society. And that emphasis on democracy is key. Now, if that was as fundamental as a civil right that you have in democracy, then what is the place of the protection of gender-critical belief within a political party? Now, as it happens, and what my case showed was is that whilst you are protected from sex realist belief within a political party, the thresholds are arguably, and I think this was a correct judgment, higher. What this means is that we want to ensure and facilitate free speech, particularly within political associations. We want people to be able to interrogate and justify their viewpoints such that they're going to make primary legislation on the basis of it. And this does mean the same way that we don't have a right not to be offended, we do also suffer from a higher threshold, so to speak, on the burden of when does that offensiveness become a problem. In the same way that I haven't yet and don't intend to, or this isn't an invitation to the fanatics of my own party, although I don't intend to pursue somebody for libel, for example, or defamation, because I've been called a TIFO, right? I also want to be able to exercise the right to attack verbally a position which I regard as profoundly wrong. And so what the judgment found in my case was that we need to be able to protect, as a result of the Human Rights Act, which is codifying, of course, the European Convention of Human Rights, Articles, in particular 9, 10, 11, freedom of belief, expression of belief, and association, and also, belief itself, belief, expression, and association. And the judge in that case concluded that there were some fundamental party rights. He was specifically talking about the context of a political party, which is instrumental towards the service of democratic institutions in this country.
1 minute.
He was particularly focused on the fundamental party rights and how can we negotiate protecting a very high bar on limiting speech with this additional right to be protected from any form of discrimination under the Equality Act. And so it was proved in my case that I had been the victim of direct discrimination. And as if that wasn't bad enough, the party then, following my win and following the cost hearing and at great expense, they're now looking, unfortunately, at bankruptcy. Because the last thing you and I would do if we were heading an organization which just lost a discrimination case is to do the whole thing again. I mean, that's called persecution and victimization. So that's the situation which the party currently finds itself. And I will revert within the discussion the other points that I wanted to make about freedom of religious belief and how I think that the ECHR is actually particularly helpful in some of the toxicity that we're finding in terms of race relations in this country. Thank you.
Fantastic. Thanks for your answer. Okay, on my left, we have Professor Gannon Phillipson next.
Thank you. So I'm looking forward to debating this question and defending the Human Rights Act and ECHR as key components of our democracy. But it's really important that we engage in this debate in a careful and informed way, not propelled by misinformation, misleading stories. So let's recall a couple of basics about the Human Rights Act and ECHR taken together. Parliament remains sovereign. It has the final say over our rights in domestic law. Courts can't strike down statutes if they find breaches of ECHR rights. They can only issue declarations of incompatibility, which Parliament and the government are not legally obliged to follow. Yes, the UK is obliged in international law to follow rulings suggested by the European Accord, but as I will show, these are extremely rare. So, to immigration and asylum, why the hostility has been the greatest. First, let's be clear what the actual issue is. Michael Ellis, former Conservative Attorney General, has claimed that it is simply a fact that remaining in ECHR means our government will be unable to deliver meaningful reform of our immigration and asylum system. That is misleading, because the ECHR says nothing whatever about immigration in general. States are entirely free to set their own policies of how many visas they do, for what purposes, tourism, work, etc. The UK could drastically reduce immigration tomorrow, and the ECHR would say nothing about it. The ECHR only applies to the issue of returning those with little right to stay here, often failed asylum seekers, to their own or third countries. And it does so in two ways. First, it prevents return where there's a real risk of death or inhuman treatment or torture under Article 3. And second, it prevents deportation. Where doing so would have a seriously destructive effect on their family in the UK under Article 8. So as to the first, it's important to note that this is not an invention of the Strasbourg Court, as is sometimes said. The UK signed the UN Convention Against Torture, UNCAT, in 1985 under the Thatcher government. Article 3 of UNCAT, in terms, prohibits states from extraditing people to states from people where there is a substantial risk of them being tortured. As to Article 8 and family life, it's in this area where I think the most misleading impressions have been spread. So some basic facts. In the last 45 years, 29 cases were brought to the European Court against in UK re-deportation. The government won 16 of them. Of the 13 cases the UK lost, just 4 concerned family life. So on average, it's been calculated judgments of the European Court of Human Rights prevented removal of a foreign national once every 4.5 years. The latest example in 2020 was the court ruling a Nigerian man convicted of falsifying immigration documents could not be deported because of the impact on his 3 young and financially dependent children, all of whom British citizens and one of whom need with heart surgery. Okay, fine, you might say, what about the Human Rights Act? Well, here too, successful human rights-based appeals against deportations are rare. the latest Home Office figures show that over the 5-year period to June 2021, 26,000 foreign offenders were deported. Of these, 645 successfully challenged their deportation on Article 8 grounds. That is 1/40th of the total, 2.5%. Add those who resisted deportation because of the risk of torture or ill treatment on return, and you still only get to 3.5% of the total number of such deportations. And that's partly because Parliament and government together have made detailed rules that provide a complete code for the judges to apply when they determine Article 8 claims of deportation cases. So the judges decide cases on the basis of the rules and exceptions formulated by Parliament. The key rule is that the Home Office must issue deportation orders against any foreign national sentenced to imprisonment of 12 months or more. There are only narrow exceptions, and they only apply in cases of serious damage to family life or risk of torture or ill treatment. So how has the perception gone about that deportations are constantly being frustrated by what Kemi Badenoch has called comically ludicrous interpretations of the ECHR? As a recent Bonavera report shows, there are 3 kinds of errors in reporting which reflects this. First of all, decisions of first-tier tribunals in favour of deportees are often recorded as final, despite having been already overturned on appeal. Second, claims or arguments made by lawyers for a deportee are sometimes reported as if they were the judgment of the court. And third, a fact mentioned in the judgment is sometimes reported as the reason for the decision. So some quick examples before I finish. 2 of those errors were the basis for a very widely reported but wholly false story that an Albanian man could not be deported because his son loved chicken nuggets so much. In fact, the initial decision to block his deportation was overturned on appeal, and in any event it never rested on anything to do with chicken nuggets. It was something simply mentioned in the first-tier tribunal. But by the time the story had started being reported, the original decision blocking deportation had already been overturned on appeal. Before that story had legs, both Kemi Badenoch and Nigel Farage allowed him to attack the ECHR. Similarly, it was widely reported that a paedophile couldn't be deported to Pakistan because he would be persecuted as an alcoholic, about which Kelvin Mackenzie said he couldn't make it up, but he was deported because the decision was overturned on the field, something not reported. Or finally, a few years back, Theresa May's Home Secretary telling the Conservative Party conference that a tribunal had recently found him that an illegal immigrant cannot be deported because, and I am not making this up, he had a cat. In fact, his having a water cat with his partner was something mentioned in the judgment as part of the long description of the life and build of his partner, but wasn't on the basis of the decision. So in a very real sense, she was making it up. So to conclude, by all means, let's debate Article 8 and indeed the ECHR, but please let's have the debate on the basis of an accurate understanding of how the Convention actually works, and in particular the very, very small contribution it makes to the problem of deporting those who have no legal right to stay in this country. Thank you.
Thanks, Gavin. Thank you. Okay, and last speaker on the right is John Holbrook.
So let's just stick with this issue of the small boats. If you think about it technically, it's a very easy problem to solve. You simply need to detain everybody who comes here illegally, and then you deport them. That should not be difficult. And if you can't return them because their host countries refuse to take them, you just take them off to a faraway barren island, of which we have got plenty. And as soon as you start doing that, all of these small boats will stop coming. That's what the Australians did, and it's effective. So the question we have to ask is why, even though this has been top of our political agenda for many years now, and even though the problem is getting worse with each year, and even though Keir Starmer, the doyen of the human rights movement, claimed he knew how to solve this problem, he can't. I mean, Starmer said he was going to smash the GANs. The only thing that has been smashed is the records in terms of people coming here every year. So what this shows is a political class which is impotent. And that is highly problematic for a democracy, because we elect people on the basis that they make promises to us which we the people want and which they then carry out. And they are simply failing. And anyone who doesn't face up to that is playing with our democracy, because people will then lose faith in it. Now, Gavin says this has got very little to do with human rights. I disagree. Articles 3, as he's mentioned, and Articles 8 are regularly in play whenever you try to do what you need to do to stop these illegal entrants. Gavin says, well, there's very few declarations of incompatibility made. True, but it's irrelevant. The point is, of the 20 or so that have been made by our Supreme Court, in every single case, or nearly every single case, the government has responded by changing the law. The second point is that few ECHR cases in recent years actually deal with Britain. True, but irrelevant, because there have over the last few decades been plenty of cases involving Britain and other member states in Europe, which has established a framework of human rights laws which scuppers the ability of states to do what they need to do to protect their borders. Gavin says only a small number, I think he said 3.5% of people being deported actually challenge them with human rights arguments. True, but irrelevant. Because what it means is that time after time, anyone who wants to deport someone knows they face the risk of a challenge, and you frequently get challenge after challenge. And ultimately, because the system is made so difficult, many in the Home Office and other enforcement agencies simply don't bother. That's one of the reasons why we in this country had such high percentages of asylum seeker grants as compared to applications made, even for nationalities where in other countries they have much lower percentages, much lower. It's simply a case of our system saying, look, this is going to be so much trouble, let's just grant you asylum and then we're done with it. The problem is that the ECHR has weaved a system of controls and restrictions over every public body that deals with these issues and every court and tribunal, such that there's now no need for anyone to trot off to the ECHR or even to raise a challenge in our domestic courts, because we know the system is compliant with human rights laws. And because it's compliant with human rights laws, you cannot defend our borders. And I could make much the same rights, not just about immigration, but also about policing and crime, about social welfare, in fact, just about any political issue you care to talk about. You will find that all of those policies now take place essentially by threading the eye of the needle. In other words, by politicians only being able to do what human rights laws and their very active lawyers will allow you to do. Now, on the more fundamental question, is this simply a problem of how these laws are being interpreted and so on and so forth? I would advance three fundamental problems that I have with the very notion of human rights. First is philosophical, which is that they are premised on the idea that there are rights which we have, which are both timeless or universal in terms of time and place. I fundamentally disagree. I believe that different cultures and different societies and different nations are different. And moreover, what we think is right today isn't necessarily what we thought was right yesterday, and it certainly won't necessarily accord with what we think tomorrow. So that's the essence of democracy. Democracy is about engaging with changing times and meeting the arguments and aspirations that people have at the particular time. So the notion of a human right, which is universal, is nonsense from a philosophical perspective. Politically, human rights are also very damaging to our democracy, because the essence of democracy is that it is the people who are sovereign. They express that sovereignty by expressing their representatives. The problem is that human rights place limits on what those politicians can do. Sometimes Sometimes the sophisticated argument is, you can't have a democracy unless it also guarantees human rights. I don't agree with that. I think you can trust the people to respect what are legitimate rights of people. Finally, from a constitutional perspective, the notion of human rights is flawed because it puts the judges into a political role. It's often said, and it's true, that it's the role of politics and politicians to make the law, and it's the role of judges to interpret and apply those laws. That's correct. But unfortunately, once you introduce human rights into your constitution, it is very often the human rights laws and lawyers that have the final say.
So the wonderful panel.